right, is the state ready to proceed?
Yes, Your Honor.
Okay, is the defense ready?
Yes, Your Honor.
Okay, very good. Ms. Convery?
Good morning to the court.
Good morning.
We're here before the court as a result of the jury verdict on April the 1st of 2019 on indictment number 17 SC 149755. I have sent to the court and to defense counsel essentially the analysis of the breakdown of the indictment. I'll state it on the record for the purposes of this hearing. On count 1 of the indictment, participation in criminal street gang activity, the sentencing range is a minimum of 5 years and a maximum of 20 years. Count 2, malice murder, has a range of life to life without the possibility of parole. Counts 3, 4, 5, and 6 are felony murder counts that I believe in this case, given the jury's verdict, will vacate as an operation of law. Count 7, armed robbery, the court should sentence on that count. The minimum is 10 and the maximum is 20 or life. The count 8, aggravated assault with a deadly weapon as a result of the jury's verdict in this case will merge with count 2, malice murder. That's the aggravated assault shooting count. Count 9, aggravated assault, the striking count is a mandatory minimum of 1 year and a maximum of 20 years. The court should sentence on that count. Count 10, tampering with evidence, also court should sentence, and it's a range of 1 year to 3 years. Count 11, concealing the death of another, same recommendation that the court sentence on that count. The minimum is 1, the maximum is 10. And count 12, if convicted, I believe the court should sentence the defendants on that count. It is a 5-year sentence to run consecutive. And count 13, in this case only, as it pertains to Mr. Gibson, is a minimum of 1 year and a maximum of 5 years.
All right, now from the court's review of that information, which I did request in advance and was provided, would you agree, also asking defense counsel, count 6, Mr. Lockett was not charged with count 6, would that be correct?
That is correct.
Okay, and as to count 12, Mr. Lockett was found by the jury to be not guilty of that account.
That's correct.
Okay, all right.
I have a recommendation on behalf of the state of courts as a result of the evidence in the jury's verdict in this case. I also do have one victim impact statement from Mr. Larry Dean. So I'll have the court let me know if you would like to hear that sort of at the front end or after I make my recommendation to the court.
I'd like to hear all the evidence, whatever is going to be submitted, victim impact or otherwise, from both the state as well as from the defense, and then I'll be happy to hear your recommendation.
All right. I'll tender to the court certified copies of convictions of States Exhibit 632 and 633. I previously shown to defense counsel. Let me take another quick look. In this case, Your Honor, the state filed a recidivist notice as it pertains to Mr. Lockett on the 16th of January 2018. That notice lists several convictions, making him a and C recidivist. Since this conviction and while the trial was pending, I've had an opportunity to review those previous convictions. There are several convictions that were actually Mr. Richard Lockett, Mr. Christopher Lockett's brother. Excuse me. So I did a careful review of the previous convictions of Mr. Christopher Lockett, and I believe they are these two. So it will be States Exhibit 632. Which is indictment number 15 SC 135065, a conviction, and 633 is a certified copy of the conviction 14 SC 124288, a conviction out of Fulton County from October the 7th, 2014 for possession of marijuana with the intent to distribute and possession of a firearm or knife during the commission of a felony.
Sir.
Who's fine? Edwards.
He was trying to redirect you.
Good morning, y'all.
Good morning, Mr. Dean.
My name is Larry Dean. I'm Christopher's father. Chris was getting his life on the right track. He told me he had a few things he had to do before he quit the drug dealing. Unfortunately, Chris never got to do those things. Chris's family life was great with his two sons. They were everything to him. Chris always took CJ to school and picked him up every day. We spent a lot of time with each other. We lived together. Chris and I were very close, and especially with my grandson CJ. His death has affected the family greatly. It was so very hard for me to tell a 5-year-old his daddy would never come home. CJ wanted to know why, and I explained it to him the best I knew how. We all have empty space in our hearts for Chris. There will never be no more birthday celebrations, no more Christmas days, no more opening Christmas presents, no more Thanksgiving dinners. Aaron, his youngest son, he was one when Chris passed. He will never know his dad except through what CJ can teach him. My heart will always miss Chris. And thank you for letting me speak about my son.
You're welcome, Mr. Brown. Thank you.
I'm going to approach with the certifying.
Yes.
This court sat through the evidence and heard the testimony in this case. The jury returned a verdict on all of the defendants in this indictment, but speaking specifically to the court about the defendant before you now, Mr. Christopher Lockett, it was the state's theory and it was supported by the evidence that Mr. Lockett did in fact plan and have this execution done at 835 Sandy Creek. It is Christopher Lockett that directed Christopher Dean, his associate at the time, to 835 Sandy Creek, where for approximately 40 minutes he was tortured before he was executed by being shot through the back of the head. The court and the jury in this case heard evidence about gang affiliation, the motivation for this crime, but I think most specifically and most horrifically is the way this crime was carried out. The court got to see the comings and goings and essentially murder headquarters happening at Mr. Christopher Lockett's residence. As a result of the egregious nature of not only the injuries, but the planning and time that went into the execution of this man, the state of Georgia, on behalf of the citizens of this county, the family in this case, and every agency involved, makes the following recommendation to the court for sentencing as it pertains to Mr. Lockett only. On count 1, criminal street gang activity, the state's going to recommend 20 years to serve. On count 2, malice murder, state's recommendation is life to serve without the possibility of parole. Counts 3, 4, and 5 will vacate by operation of law. Count 6, Mr. Lockett was not charged. Count 7, armed robbery, state's recommendation is life to run concurrent with count 2, malice murder. Count 8 in this case will merge, aggravated assault will merge into count 2, malice murder. Count 9, aggravated assault as a result of the striking with an object. State's recommendation is 20 years to serve concurrent with the court's sentence on count 2, malice murder. Count 10, tampering with evidence. State's recommendation is 3 years to serve to run concurrently with the court's sentence on count 2, malice murder. Count 11, concealing the death of another. State's recommendation as to sentencing is 10 years to serve to run concurrently with the court's sentence on count 2, malice murder. Count 12, possession of firearm during the commission of a felony. The jury returned a not guilty verdict. those recommendations complete the state's recommendations for Mr. Lockett on 17 SC 149755.
All right, thank you.
And Mr. Lockett, just for purposes of the record, on the 2 convictions I've tendered to the court, there is one open case as well that the court knows about. It's 17 SC 150167. That's the drug and firearm case as a result of the police encounter at 1669 Joseph E. Boone.
Well, that,
I believe so. I have not spoken to defense counsel about any resolution, but I
Okay.
believe this disposition is possibly going to resolve that as well.
okay. All right, is there anything else from the state?
No, Your Honor.
Okay. Mr. Hudson, on behalf of your client, Mr. Lockett.
Thank you, Your Honor. Just very briefly. There's really not much I can say. The jury has spoken. They sat and listened to the evidence in this case, and they returned their verdict. And I'm not inclined to go back and relitigate the trial. I will say that this is obviously a tragedy on all fronts. Mr. Dean's family has lost a great father, great son, but they'll never see him again. But Mr. Lockett has a family as well, Judge. He has a loving mother and a kind brother, and they are just as heartbroken about this as well. And Judge, just by way of slight mitigation as it relates to Mr. Lockett, he grew up in what I would consider to be a fairly broken home. His brother, one of his brothers was shot and killed. Another one of his brothers spent some time in prison. That would be Mr. Richard Lockett, who Ms. Convery alluded to earlier. And so we have this cycle here that just is not broken. And the court has the ability to at least give Mr. Christopher Lockett perhaps a chance. Should the court sentence Mr. Lockett to life as opposed to life without parole, there is no guarantee that the Department of Corrections will parole him, but it's a chance. And it's a chance that I'm asking the court to afford Mr. Christopher Lockett. I agree with the state's breakdown in terms of sentencing. My recommendation, however, would be on count 2, that the court would sentence Mr. Lockett to life as opposed to life without parole. And for the remaining counts, I would ask the court to run those sentences concurrently with count 2, and hopefully the Department of Corrections will act accordingly. Again, this is just the court affording Mr. Lockett some sort of chance. It's not guaranteed that he would be paroled if the court does do a life sentence as opposed to life without parole. Thank you.
Thank you. Does your client wish to say anything?
No, Your Honor, he does not.
Okay. So this case, which was tried before a jury at the end of April, as I recall, end of March, and we finished at the very beginning of April, for the court certainly was not a usual trial. The facts of the case were horrific. the circumstances leading to all those that were involved coming together are complicated and certainly sound out to our community of the need for more to be done. A life was taken, a life and lives will be affected as a result of the court's sentencing. We were in a different courtroom during the trial. We were in a much larger courtroom, but I had a good vantage point of everyone that attended each and every day. There clearly was very keen interest by the community in what was taking place. I was very much aware of Mr. Dean, where he was sitting and how he was composed and as he heard what had taken place. And I would certainly like to express to you, Mr. Dean, I'm just so very sorry for what has happened. It's very difficult for any parent to lose a child, period. And to have your offspring leave the world before you do is a pretty sobering experience under any circumstances. But certainly these circumstances, I just can't begin to try to relate to how you must feel, except as a parent, I know that it has been traumatic and will affect you and your family forever. Hopefully, and I know that you will be there for your grandsons and will help them to make better choices, even that your own son made. But I know that you will be there for them. You indicated, I think you referred to him as CJ, but CJ wanted to know, well, what happened? And quite frankly, or why, I guess, was the question. And quite frankly, I think we all kind of want to know why. There just isn't a good reason for what took place. And our community deserves better than what took place. But we have a system, and the system in this case, under the court's watch, I believe, did what it needed to do. It listened to the evidence. The jurors that were selected from all over Fulton County spent a lot of time. They were very attentive. They were very respectful of the process. They kept an open mind until it was time for them to deliberate. They deliberated over a significant period of time and made their decision. And so as a result of the decision, this court has its now responsibility of sentencing. There are 5 defendants that were tried. There were actually 7 defendants that were charged. We went forward with 5 of the individuals. And I intentionally wanted to do the sentencing individually with one defendant in the courtroom at a time, because each individual is an individual, and I think is entitled to have the court focus just on him in this regard. So I am prepared at this time to proceed with the sentencing. I will start actually with count 2, which is the malice murder charge, and will sentence Mr. Lockett to as a recidivist to life without parole. Counts 3, 4, and 5 will vacate as by operation of law and be merged into count 2. We then have count 1. The court will sentence Mr. Lockett to 20 years to be served concurrently. We have count 7. The court will sentence you to life on count 7. Count 8 is going to merge into count 2. Count 9, the court will sentence 10 years to serve. Count 10 will be 3 years. count 11 will be 10 years. Are there any questions about the court's sentence?
9, 10, and 11, are those all concurrently?
Yes. So having sentenced you, Mr. Lockett, there are certain things that I'm required to make sure that you are aware of. You do have a right to file a motion for a new trial and to have an appointment of counsel to assist you in doing so. You have the right to seek post-judgment relief from your conviction by making a motion for new trial in this court and/or filing an appeal to a higher appellate court. If you want to file a motion for a new trial or an appeal, you will need to file the motion or notice of the appeal with the clerk of this Superior Court of Fulton County within 30 days. You may want to discuss your options at this point with your attorney, Mr. Hudson. If a motion for new trial is made and the court should deny it, you would have 30 days from the filing of the order of denial in which to file with the clerk of court your notice of appeal. You do have a right, as stated, to have an attorney represent you on the motion for new trial in the first level of direct appellate review. And as stated, if you cannot afford to hire an attorney, the court will provide you with one and with the transcript of the trial at no cost. I'm also going to advise you of the habeas statute of limitations. You will have a period of 4 years from the date of today, which will be the date of the sentence, to file a habeas corpus petition. The details that can affect the time within which you must file a petition are contained in a copy of the code section that will be handed to you at this time. I'm giving notice to the state and to defense counsel that we will set a date for hearing on a motion for new trial if one is filed, anticipating that we will need time to have the transcript prepared, and I would estimate that we would set down that hearing certainly within 6 months from today's date. I believe that completes what, yes, you can give that to Mr. Lockett. That completes the court sentencing in this case. Thank you to the state. Thank you, Mr. Hudson.
Yeah.
And good luck to you, Mr. Lockett.